Well, hello and good morning. Happy Sunday coffee with Dr. Childress. So, today I'm going to be discussing, uh, I'm going to be talking to the family law attorneys out there. I did a consultation with an attorney last week and it spent a lot of time reorienting the attorney from the legal system where they start to healthcare, where we're headed. And by the time when we were talking, he had all sorts of questions and problems associated with the mental health people and various issues. And by the time we were finished, we had a plan, and it was pretty clear what we would do once we shift over to healthcare rather than the legal system. And that's been one of the difficulties over here in the family courts is the forensic psychologists, when they moved out of healthcare and moved into the legal and became mini judges and stopped diagnosing and treating pathology, that broke both systems. The mental health system is no longer functional in the family courts. They're no longer responding to the pathology or the problem in the family courts, and because of that, the legal system has to diagnose pathology, and they're not set up to do that. So the the mental health system, the forensic psychology, is a real problem in the mental health system. And so I'll be talking about that. And we need to shift back into clinical psychology, which is the treatment side of things. And once we pathology, the problem is not custody. Custody is a symptom, but custody is relatively easy to resolve the issue. The issue is the attachment pathology in the child. The child's rejecting a parent. And that's what the court's struggling with because it says, is there possible child abuse? And we have one parent, just the allied parent, simply because the child is rejecting the targeted parent, is presenting to everybody that there's a child abuse issue with the targeted parent. Now, where we are shifting to is that the targeted parent is also alleging psychological child abuse by the allied parent. So we have two sides to the child abuse allegations, and we need a proper assessment to both sides. There's two litigants, two child abuse allegations, different causes, and so we need a proper assessment for possible child abuse. And that's a clinical issue. That's a healthcare issue. That's not a legal issue, at least not at first. It's not a custody issue. Custody is a symptom of the high conflict personality of the narcissistic borderline dark personality parent who wants to drive this into the courts for various manipulative reasons. So the court needs to recognize that there's a potential for the manipulation, there's a potential for pathology in the allied parent that's driving the whole issue, and it needs to get it back out to the healthcare system for proper diagnosis. So let's talk. Whoops, let me go back. I'm at the end. Yeah. So let's talk about the coming paradigm shift from custody to treatment. Uh, the forensic psychology is a failed experiment in service delivery to a vulnerable population. And so we need to be shifting back to clinical psychology. But to orient, we have two systems involved, and they are co equal systems. They're based on the same structure. Both systems can kill you, and they have roles, different roles, but they are built on the same structure. And so that's a useful way for attorneys to think about what's happening over in the healthcare system. Is we just it's just a different, the same structure, different people. So at the top in the authority for the legal system is the judges. The top authority in the healthcare system are the doctors. And the judges, the legal system holds their trials to collect their evidence, and the doctors do their assessments, clinical interviews, and whatever assessments we need to collect our symptom evidence. The courts apply their statutes and their laws to the evidence, we apply our diagnostic criteria to the evidence. And there are rules and procedures for the court. There's ethical standards for the psychologist. So the same structure here. Then the court then expands their statutes with precedent. We expand our diagnostic criteria with research. Then the court makes its ruling or its judgment and verdicts, and the doctors make their diagnosis. So it's the same thing. And then the court issues their court orders, and we issue our doctor's orders based on our decisions. And so the idea of these forensic evaluations that they 6 to 9 months, but they never return a diagnosis, that would be analogous to having, a 6 month trial and the judge never reaches any sort of verdict. He just goes straight to remedy. Okay, so the remedy, well, wait, is it guilt or innocence? Well, I haven't decided whether it's guilty or innocence. I'm just going to talk about the remedy. Remedy in the family courts, that term is treatment in healthcare. So treatment, remedy. And so it's the same sort of structure here. So what we need to do is the legal system is not set up to handle psychological pathology. That's the healthcare system. So we need to move this out into healthcare and get an accurate diagnosis. Now, forensic psychology, what's important to understand is it's an experiment in service delivery to a vulnerable population. So forensic psychology, we gave about the 1980s, we gave the families in the family court system their own special psychologists. We did that for a number of reasons. Risk management was one of the big ones, and not knowing what to do about the pathology was the other. So we said, gave it over to a select group of psychologists and said, figure this out, and forensic psychologists. Now, the forensic psychologists see themselves as making custody decisions rather than doing treatment or diagnosis. So they stop diagnosing and treating pathology, and they kind of give the courts vague answers about what's going on. A lot to protect the pathological parent. They don't want to identify, diagnose the pathology in the parent, and it's personality pathology. Everybody knows it's narcissistic, borderline, dark personalities in the family courts, but they don't want to give those labels because then that prejudices the court against the pathological parent. However, that's withholding relevant information from the court. That is a narcissistic, borderline, dark personality parent, and they're twisting up the child. And the court has a right to know that. So doctors shouldn't be putting their fingers on the scale of justice by withholding information from the court. And by withholding, they are prejudicing the case in favor of the pathological parent by withholding information about the severity of their pathology from the court. So that becomes really problematic. I have a whole lot of problems withholding information or shading information to the court. I'm a doctor. I diagnose pathology. I will tell the court what the diagnosis is, and I will explain the diagnosis to the court, but I'm not going to withhold diagnostic information from the court's consideration in order to protect the pathological parent and the potential psychological abuse of the child. So forensic psychology treats just family court pathology. That's it. Everything else is treated by clinical psychologists. And so clinical psychologists are the treatment doctors. Forensic psychologists are the custody doctors. And there's a whole lot of problems with being a custody doctor here. See, so what's happening right now, because the forensic psychologists left healthcare and became mini judges in the legal system, that forces the legal system then to solve everything. They're not getting appropriate services out of the mental health system. So when there's child and family conflict, it goes into the legal system. Then the legal system, the attorneys will do their various motions to try to resolve the custody issues involved. And to get mental health involvement for the last 40 years, they would seek a custody evaluation, child custody evaluation, because that's what professional psychology, that's the only thing professional psychology offered to them. All the clinical psychologists left. So you haven't had clinical psychologists in the family courts for 40 years, which is why you have no treatments over here. We have dialectic behavior therapy, solution focused therapy, internal family systems therapy, emotionally focused therapy, cognitive behavioral therapy. We have all sorts of treatments for everything in clinical psychology, but you have nothing in the family courts. Reunification therapy doesn't exist. There's no definition of that. It never works. And so 40 years you had no successful treatment over here because you've excluded the treatment psychologist from the family courts. And it's an experiment. And the problem I have with the experiment is that the professional psychology never told the parents or the court about alternatives to a custody evaluation, a clinical diagnostic assessment for possible child abuse. But they withheld that service and that information from parents in the court. The clinical diagnostic assessment, we can probably pull that in 4 to 6 weeks for around, $2,500, $5,000. But they do this big 6 to 9 month custody evaluation for $40,000 that doesn't diagnose the pathology, doesn't solve anything. 2 years later, you're doing an update forensic evaluation because it didn't solve it 2 years ago. And it's been a failure for 40 years. This is a failed experiment. They've been using these parents in the family courts, the APA, AFCC, these forensic psychologists have been using these parents as guinea pigs for their experiment. I'll cite to Simon and Stahl, and we'll get into that over the course of time. But it's a failed experiment. It needs to end in the family courts. So the only input currently available is within the legal system, these awful forensic custody evaluations. So here's from the New York Blue Ribbon Commission on Forensic Custody Evaluations. And I think this is important for everybody to understand what's happening in professional psychology. There's a paradigm shift. The courts have been abandoned by the American Psychological Association, by professional psychology. You are not, the judges, the court system, legal system is not getting appropriate information from mental health. We have absolutely failed you. The professional psychology gave you an experiment. It absolutely complete and utter failure. And so you're kind of stuck. So here's from the New York Blue Ribbon Commission. It says, ultimately, the commission members agree that some New York judges order forensic evaluations too frequently and often place undue reliance on them. Judges order forensic evaluations to provide relevant information regarding the best interests of the children. And some go far beyond an assessment of whether either party has a mental health condition that has affected their parenting behavior. And so that last line is important, that they go beyond whether either party has a mental health condition that's affecting their parenting. So that's what we need to get back to. That's what the court wants. That's the information the court needs. Does either parent have a mental health condition affecting their parenting? In the absence of child abuse, parents have the right to parent according to their cultural values, personal values, and religious values. So is there child abuse? In the absence of child abuse, each parent should have as much time and involvement with the child as possible. So is there child abuse is the relevant question. And in the absence of child abuse, to restrict either parent's time and involvement with the child would damage that child's attachment bond to that parent, thereby harming the child and harming the parent. So it's not in the child's best interest to restrict time with either parent because it's going to damage the child's attachment bond to that parent. And it is always, from clinical psychology, it is always in the child's best interest to repair the relationship. Cite the Tronic and Gold, The Power of Discord. We always repair the relationship. So it's always in the child's best interest to fix the family pathology. So to do that, we need an accurate diagnosis and an effective treatment plan. Diagnosis guides treatment. Treatment for cancer is different than the treatment for diabetes. So we need to identify what the diagnosis is. And there's specific diagnoses of concern that we need to be looking at. So more from the Blue Ribbon Commission. And you can Google this, Blue Ribbon Commission. It shows up, New York Blue Ribbon Commission. In their analysis, evaluators may rely on principles and methodologies of dubious validity. Absolutely. I read them all the time. I'm a consultant on this. This parental alienation is what they're talking about. New one is resist refuse dynamic. Neither of those exist. They're just making things up. That's a dubious validity. They are not applying any established knowledge, not attachment, not family systems, not delusional thought disorders, not the DSM-5, not um, complex trauma, nothing. They apply no information, no established information from professional psychology. I know I do line by lines to highlight that issue on these custody evaluations. So they're in violation of multiple ethical standards. 2.01 boundaries of competence, 2.04 bases for scientific and professional judgments, and 9.01 bases for assessment. So yeah, dubious quality, dubious validity, absolutely. In some custody cases, because of a lack of evidence or the inability of parties to pay for expensive challenges of an evaluation, defective reports can thus escape meaningful scrutiny and are often accepted by the court, with potentially disastrous consequences for parents and children. Absolutely correct. I am the meaningful scrutiny. That's my current position. I'm a consultant in the family courts, going through these forensic custody evaluations line by line because I am the meaningful scrutiny for these defective reports. But it's like a surcharge. You have to pay for the custody evaluation, then you have to pay for Dr. Childress to do his workup on it. And it's just financial exploitation of these families, massively, massively. It's just horrific. These custody evaluations are just horrific. So he goes on to say that by an 11-9 margin, the majority of commission members favor elimination of forensic custody evaluations entirely. So that's where we're headed. So if you're in the family courts right now as an attorney, understand forensic custody evaluations are going to be disappearing. It's a failed experiment in service delivery to a vulnerable population. There's massive ethical violations. They are absolutely the worst, dubious validity, and elimination custody evaluations, arguing that these reports are biased and harmful to children. Yes, I agree with that. Absolutely. Because they're biased and they're wrong in many cases. They apply no knowledge. They're just making stuff up. And they are harmful to children and lack scientific or legal value. Absolutely correct again. So if they lack scientific or legal value and potentially harmful to children using constructs of dubious validity, they need to be gone. It was a failed experiment. If you want evidence of how it's a failed experiment, look at the situation around you. This is based on 40 years of forensic custody evaluations since the 1980s. Is anything solved? No, it's still a nightmare in the family courts. It's a failed experiment, and it's just what the professional psychology has done to these families and to the court system is horrific for the last 40 years. There needs to be self-reflective insight by the APA on what happened in the family courts and why were standards of practice allowed to just bottom out like this for so long with nobody getting involved, nobody solving anything. So they lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence or child abuse. Yeah, so we got dangerous mental health services being provided in the family courts that are mental health services that are harmful to children and parents, potentially disastrous consequences from the mental health services in the family courts. And that's correct. If you believe a shared delusion, you become part of the shared delusion. And when that shared delusion is child abuse, you become part of the child abuse. So there's many, 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 many forensic psychologists who are part of the child abuse. I would say all of them. So that'll be an interesting kind of thing because they're practicing beyond the boundaries of their competence, failing in their duty to protect as a result because they're not accurately diagnosing the pathology. So, what they come up with is members reach the conclusion that the practice is beyond reform and that no amount of training for the courts, forensic evaluators, and or other court personnel will successfully fix the bias, inequity, and conflict of interest issues that exist within the system. It's irreparable. And so, for family law attorneys to begin to wrap your heads around that issue, that forensic custody evaluations are headed out. They're extraordinarily problematic. And so, New York is potentially stopping them. And I think other states will follow suit once you get state legislators to start looking into this forensic custody evaluation stuff. They're gone. They're gone. And we're going to be returning back to clinical psychology. The problem right now, though, is you don't have any clinical psychologists in the family courts. And for a clinical psychologist to come over here from, let's say, domestic violence or dialectic behavior therapy, borderlines or something, they don't have experience in the family courts with the custody and the attachment pathology and stuff. So they would be practicing beyond the boundaries of their competence. They don't have the education or training or experience working in the family courts with this particular pathology because we've been away from it for 40 years. We've been banished from the family courts for 40 years, which was a bad idea. But you don't have any clinical psychologists now. So that's what you're heading into in the family courts is you will have no mental health input when the issue is potential child abuse. That's a significant problem. And so in this transitional phase, we're going to have to do what we can to help scaffold the mental health people in the family courts, either forensic psychologists, rehabilitate them. If you got somebody who's ignorant, unethical, and lazy and incompetent, and they don't care, I don't want to rehabilitate that person. That person has shown themselves to just not be somebody that's workable. They're just lazy and they're unethical. So I would say get out to clinical psychology, dialectic behavior therapists, the IPV, intimate partner violence people, see if you can bring them over as well. But you get related experience, but then we'll have to scaffold them up in their understanding of the court involved attachment pathology. So going back to the issue that was first raised or that was raised by the Blue Ribbon Commission, that these forensic evaluators go off into other issues that are not relevant to the court's consideration. When you're asking a doctor what's going on, we return a diagnosis. And so that's, going back to a second. Yeah, so when it says some go far beyond an assessment, right at the end there, of whether either party has a mental health condition that has affected the parental behavior. That's what the psychologists need to focus on, whether either parent has a mental health condition that is affecting their parenting behavior. And the issue involved with that is two psychological pathologies here. One is a thought disorder in the parent. The type of thought disorder is called a delusion. That's a fixed and false belief maintained despite contrary evidence. The type of delusion is a persecutory delusion. This is a thought disorder out of trauma. It's not a schizophrenia type delusion. It's out of trauma, unresolved trauma. That the person's childhood trauma has distorted their thinking and perception to where they see dangers where none exist. That would be classically described as a narcissistic borderline dark personality. The childhood trauma created the personality pathology that distorts their thinking and perception. But it gets down to the specific, though, is a shared persecutory delusion. It's a shared, or also called an induced persecutory delusion. That's been in the DSM for a number of years. It was taken out in DSM-5 because the APA, American Psychiatric Association, doesn't like shared diagnoses. But in this case, it needs to come back. Um, I think in our social surround, we're experiencing a shared persecutory delusion, an induced persecutory delusion. So that's going to be more and more evident. And so I anticipate in future revisions of the DSM that shared delusional disorder will come back, and it'll move from the psychotic section over to the trauma section. But that's down the road. Um, so we're worried about, in this particular family court, we're worried about a parent, the allied parent, who potentially has a thought disorder. We're also worried about the other targeted parent and actual child abuse. So we'll assess for that. That's one possibility. But with the allied parent, the concern is a thought disorder, shared persecutory delusion. Um, and then the other potential pathology is a factitious disorder imposed on another. Classically, that's Munchausen by proxy. I work Children's Hospital. I know Munchausen's. I know factitious disorders. And what we have in the family courts is a factitious, a false attachment pathology being imposed on the child for secondary gain to the parent of manipulating court decisions about child custody and to meet their own needs. So we have factitious disorder, factitious attachment pathology, and a shared delusion, that the persecutory delusion, that's all kind of mixed up here. Now, both of those diagnoses, though, wind up on the diagnosis of child psychological abuse, and that's a DSM-5 diagnosis of V995.51. So that's the diagnosis we're looking to get. Either child abuse by the targeted parent, in which case we protect the child from the targeted parent, or child psychological abuse by the allied parent, in which case we protect the child from the pathological narcissistic borderline dark parent. So either one of those, false attachment pathology, FDIA, is considered child psychological abuse, creating a shared induced psychosis in the child that destroys their attachment bond, is child psychological abuse. Diagnosis guides treatment. And so the treatment for cancer is different than the treatment for diabetes. So treatment for child abuse by the allied parent is different than the treatment for child abuse by the targeted parent. So we need that diagnosis, which parent is abusing the child. And with severe attachment pathology, a child rejecting a parent, the only cause of severe attachment pathology is child abuse by one parent or the other. If it's not abusive parenting, range parenting, then we see different types of symptoms. We don't see a rejection of a parent. We see insecure attachment, which shows up differently. So if we're seeing a child reject a parent, there's child abuse. We just don't know which parent until we conduct the assessment. So that's the issue in the family courts. It's not about custody. It's about child abuse. And we need to get a proper assessment and accurate diagnosis of pathology. So going back to what the legal system is currently trying to do by solving everything within the legal system, ultimately we need to shift back when forensic custody evaluations collapse and we can maybe get the clinical people back. This is the framework to bring the clinical people back. And it maintains the two systems collaborating, but we're not getting mixed up. When the forensic people, the forensic psychologists left healthcare and went over to the court system, they did a very bad thing because they broke both systems. They left their role. And so part of what I'm doing in the family courts as a clinical psychologist, I'm staying within my role as a doctor. Doctors diagnose and treat pathology. I don't deal with custody. That's a court's decision. Doctors diagnose and treat pathology. And so that's what needs to happen. And that's what we need to provide, those exceptionally good quality services and diagnosis and treatment to the family courts. And then that's how we can keep the clinical people safe coming over here, is by defining what um, is by going back to standard clinical practice, diagnosis and assessment. It's dangerous. We should get second opinion consultations so that the court can rely on decisions and protects the diagnosis of the psychologist involved from retaliation from the narcissistic borderline dark personality parent. And opposing counsel, legal system needs to understand the pathology in the family courts, and opposing counsel needs to understand we're dealing with child abuse here. And so we're a little bit out of the zealous advocate role for them, because they could potentially be misleading the court if they use their legal knowledge to participate in the child abuse, to keep the child abuse going by delays and those sorts of things. And when there's child abuse involved, I think everybody, all the court officers of the court, and all the mental health people need to get on a different orientation. We need an accurate diagnosis. When child abuse, possible child abuse, is a considered diagnosis, which it is in the family courts, our diagnosis has to be accurate 100% of the time, because misdiagnosing child abuse is too devastating to the child. And there's ways we can do that in healthcare, but we need to step up. The mental health system is failing the courts. Absolutely. So I have no problem with the failure of the legal system at this point, because the legal system is not getting proper information out of the mental health system, and it should be. So we're failing the parents, we're failing the children, we're failing the courts. American Psychological Association needs to get over here, needs to look at what's happened with forensic psychology, kind of do a post-mortem on what happened for 40 years and how they just destroyed the lives of thousands of children with their neglect of what's happening and their participation in the abuse of children and the destruction of their parents' lives and children's lives. It's going to be bad once self-reflective insight comes. The APA relied on the forensic psychologists, and the forensic psychologists failed the APA as well. So now the APA is going to be in a load of mess. But what needs to happen is when you get into the family courts, any pathology, any attachment pathology, the moment you see the attachment pathology, and you get in you've already decided on custody, but it's coming back, somebody can't manage whatever the custody orders are, and you got the child is involved in attachment, rejecting a parent and stuff. Don't worry about figuring it out yet. Let's get a proper assessment that reaches an accurate diagnosis and a treatment plan. Then that can be brought back into the family courts as evidence. And then the judge and the courts can look at the diagnosis and treatment plan, make a decision about that, and then kick it back out to the healthcare system to implement the treatment. And so it's a movement back and forth between two systems that understand each other's roles and understand what each other is going to be doing. And once we get this structure, then the attorneys and the psychologists can begin to work together to understand the approach. And so it'll be a fairly standard approach for the judges. The court orders will be fairly standard. You see the coming in, well, let's get it kicked out and to the healthcare. Let's get a proper risk assessment for possible child abuse. And, going back here, that's that final line there, that we need to go back. Is there a mental health condition that when a parent that's affecting their parenting behavior? That's the question that the court wants to know from the psychologist. So let's get the court that information. And although that's clinical, that's not forensic. And it's a shared persecutory delusion, factitious disorder, or child abuse by the targeted parent. One parent or the other is abusing the child. So that's the coming paradigm shift. That's the change in framework, and the change. There's going to be a change in the legal arguments being offered to the court. Instead of asking for a custody evaluation, we're going to be asking the parents and their attorneys will be asking for proper risk assessment for possible child abuse to a very specific differential diagnosis. So everybody fights about everything in the family courts because that's the system. It's an adversarial system, and that's how the court system extracts the evidence. It's an adversarial. They go back and forth. Doctors do something different. We're kind of cagey, and we do our clinical interviews and our assessments and find that our information a different way. But because everybody's fighting, the diagnosis that's returned is going to be thought about. It's going to be challenged by one party or the other. Duh. And so that's to be expected. The appellate system for a disputed diagnosis in the healthcare system. Go back for a second. So this. So in the legal system, the appellate system, you guys do things very linear. So you first reach your verdict, and then you appeal it, and then you go. Over in the healthcare system, our judge doctors, we need our diagnosis early and we need it accurate because that's going to guide treatment. So we pull our appellate system right up front. So you go into the doctor and say, "Doctor, this hurts." Boom, you're out. Let's get you an orthopedic consult. We consult all the time as doctors because it improves the quality of services we deliver to our patients. So if you're having two different quality mental health people, two different quality doctors, the consultation always raises the quality. The more competent doctor never goes down. It always raises. And that's why we do consultation all the time in healthcare. And you can just know that. Go look at medical. You go in and your general practitioner refers you out to a specialist who refers you to another specialist. And so we do consultation all the time. And that's what we need to do here in the family courts. We need to get at least 2 opinions on the assessment so that maybe 3, we got 2 parties, they can each hire their consultant and you get somebody to lead the assessment. And that's like a 3-judge appellate court. In the legal system, it'd be a 3-doctor appellate court, but it's brought right up front. So again, you can do it sequentially, do an assessment, a diagnosis, then get a second opinion. But now you're going to be fighting about the second opinion. There got 2 reports, and the way we do it in healthcare is we do it simultaneously. So you have an assessment, you get a second opinion during that assessment, maybe even a third opinion on that assessment, so that when you reach the diagnosis, it's an accurate diagnosis and it's one which the court can rely on. And we can stop the fighting around these children. That's the most important thing here. We need to stop the fighting around these children. They're getting ripped apart. It's destroying their childhoods. So we need to give the children a normal range, healthy childhood and stop fighting about them. The way we do that is by getting a certain diagnosis. Appellate system is second opinion. Let's get the second opinion. We have telehealth. And you can be sitting in any office and anywhere on the planet. And psychologists, we train supervised hours. We get years of supervised training. We have people watching us all the time, one-way mirrors in our therapy rooms. Consultation with doctors is not a problem. But the family courts fight about bringing in consultants because of the history of experts and stuff, but because that's what they do. They fight and try to stop that. The legal system, as we start to make this change, has to reorient. This is possible child abuse, and we're trying to get the judge accurate information. I don't care which parent is abusing the child. I just want to know which one so I can protect the child. In some of these cases, it's a targeted parent. Absolutely. In which case, we need to protect the parent. Protect the child from that abusive targeted parent. In other cases, it's the allied parent psychologically abusing the child, the narcissistic borderline dark parent. In which case, we need an accurate diagnosis on that and protect the child. And so the doctors, I don't care if it's autism or ADHD or an eating disorder, I just need an accurate diagnosis on it so I know whether I'm treating cancer or diabetes. What am I treating? What's my diagnosis? I need an accurate diagnosis. There's only 2 causes of treatment failure. Okay, only 2. Either A, you misdiagnosed the pathology and you're treating cancer with insulin, or B, You've accurately diagnosed the pathology, but you're not competent in the delivery of the intervention for that pathology. Because if you've accurately diagnosed what the problem is, the pathology, and you are competent in the delivery of the intervention, then you're going to fix the problem. So if you're not fixing the problem, you got one or two issues. Most likely it's a misdiagnosis. Okay, so that's the critical issue. We don't want to misdiagnose child abuse. Because we know for a fact that the only cause of severe attachment pathology is abusive range parenting. That's the only thing that causes it. Any lesser stuff causes other type of symptoms. The only thing, all these court cases should be returning a child abuse diagnosis against one parent or the other. All of them. So if you're not getting a return diagnosis of child abuse, then you're leaving the child with an abusive parent. And if it's 50-50 custody, you're giving the child over to a parent who's abusing the child 50% of the time. And no treatment's going to work as long as we're sending a child home to be abused. There's 4 diagnoses of child abuse in the DSM: physical, sexual, neglect, psychological. All of them are equally severe in the damage they do. They differ only in the type of damage they do. And when we have abuse by one parent, if you want to know how bad or get an understanding of what's happening, switch categories. Switch from psychological over to physical abuse. So this child's being beaten with electrical cords by one of their parents, and we're giving the child 50% time with that parent who's beating them with electrical cords. No, that is child abuse. We're not protecting the child if we're sending that child home to be beaten with electrical cords. That's why it is critical that diagnosis guides treatment. Everybody in the family courts, all the mental health people, and this is a problem with the forensic psychology people, but it infested everybody in the family courts, the legal professionals as well. It dropped everybody. Is everybody rushes to treatment before we have a diagnosis. What are we going to do about it? Let's get the child into reunification therapy. Well, what's the diagnosis? Treat that the reunification therapy, no such thing. But what's the diagnosis that's guiding the treatment? Oh, well, I don't diagnose pathology. Then you don't. Are you treating cancer or diabetes? What? It's insane. So the issue is child abuse. So we need to identify that. Because we need a treatment plan. And the treatment plan for child abuse is to protect the child. So we get a consultation. I recommend a simultaneous in the fighting. So the healthcare solution for this is we need an assessment, diagnosis, and treatment. Diagnosis guides treatment, and we need an assessment get the diagnosis. We need a proper assessment. That's a risk assessment for the differential diagnosis to reach an accurate diagnosis, which is child abuse by one parent or the other, which parent, so that we can develop an effective treatment plan of protecting the child. So a proper assessment is a risk assessment for possible psychological child abuse. The accurate diagnosis would be the shared persecutory delusion and the child psychological abuse. And the effective treatment would be protective separation and dialectic family therapy. There is no such thing as dialectic family therapy yet. There's dialectic behavior therapy. It needs to be adapted slightly for the court to become dialectic family therapy. But we need to get the clinical psychologist back with dialectic behavior therapy and start working in the family courts and treating the pathology here and resolving the neglect that has been involved from professional psychology for 40 years. So that's the structure of what needs to happen going forward. And, the accurate diagnosis could be child abuse by the targeted parent as well. And so that occurs, that happens. And so that also needs to be put on the table. So misdiagnosis. So in all cases, right now, there's lots of misdiagnosis. MISSED, missed diagnoses. They're not making the diagnosis of child abuse. They're missing it. That's a misdiagnosis. Is it a negligent misdiagnosis? Yeah, I'd say it is. They failed to show proper care. They failed to even assess for any of this stuff. So I would say it's negligent, a misdiagnosis from all the mental health people that's out there right now. So yeah, there's licensing board complaints and there's malpractice suits aplenty, potentially. So in all cases of court involved, custody conflict involving severe attachment pathology, a proper risk assessment for child abuse needs to be conducted to the appropriate differential diagnosis for each parent. So let's get that happen. And those are the court orders that need to come forward with this. And by definition, here's some definitions. Diagnosis means the same thing as identify. Pathology means the same thing as problem. Treatment means the same thing as fix it. So we need to identify what the problem is so we know how to fix it. We must diagnose what the pathology is so we know how to treat it. And so that's the argument to the court. It's like, whoa, let's slow down on the custody decisions for a bit and let's get a proper assessment out of the mental health people as to so we can identify whether or not there's child abuse, and it likely is, and by which parent, so that we can take the proper steps to protect the child. But the court needs to rely on that. The court's not in a position to make the diagnosis. They're legal professionals. They're not trained psychologists, and this is very subtle delusional thought disorder and family conflict, very seemingly complex, that requires the application of knowledge from psychology. I don't go into the legal system and start making legal rulings because I don't know the law and I am not trained as in law school. I went to psychology school, kick it out to the doctors in psychology school. Now we have to give the court an accurate diagnosis. The way we do that is second opinion, third opinion if we need to. We do whatever we have to do to give the court a diagnosis that the court can rely on because it's accurate. My diagnosis is accurate 100% of the time, okay, because I'm a doctor. And then I'm sure the judges will say their rulings are accurate 100% of the time. And we don't like to, the doctors do not like to get overturned on appeal. We don't like to have a second opinion tell us we misdiagnosed the pathology. That's like a judge getting overturned on appeal. You messed up. And so now, if I don't know what's going on, then I will say, I don't know. And then I will identify the information that I need to collect so that I will know. Then I collect that information and then I know, and my diagnosis is accurate. And when it's child abuse, absolutely, my diagnosis has to be accurate 100% of the time because misdiagnosing child abuse is devastating to the child. It's going to destroy the child's life. So we have two possibilities. A targeted parent is abusive somehow, physical, sexual neglect, psychological, identify what it was, diagnose it, and put it on a treatment plan and fix it. Or the allied parent is psychologically abusing the child. That's a shared persecutory delusion and factitious attachment pathology for secondary gain to the parent. So what we need to do, so when you have current mental health involvement, any treatment provider, now we don't necessarily need a separate assessment because all mental health professionals have duty to protect obligations. And there's three dangerous pathologies: suicide, homicide, and abuse. That's a category of types of pathology. They're called dangerous pathologies: suicide, homicide, and abuse. Whenever a mental health professional encounters any one of those, we have duty to protect obligations, mandatory kind of legally obligating obligations, duty to protect the child. And so we have obligations to conduct a proper assessment for the suicide, for the homicide, or for the abuse. Physical abuse, sexual abuse, and neglect abuse are mandated reports into Child Protective Services because we want to protect the forensic evidence. If there's physical, sexual, or neglect abuse, we may want prosecution on that parent or on that person. And so we want to make sure that the interviews that gathered that information were conducted properly for the prosecution. So they're forensically sound interviews. So we don't want mental health people getting in there and messing with and leading questions and messing with the interviews and messing with the forensic evidence. So we get that over to the CPS people, let them conduct the interviews. Psychological abuse, the fourth DSM diagnosis, is not a mandated report because it's too complex for CPS. I've worked with CPS social workers. They're out there with really nasty stuff: physical abuse, sexual abuse, neglect abuse, meth parents, alcoholic parents, really bad stuff. That's their primary focus, is on that type. Psychological abuse is too, they can see it come in, a custody evaluation, false allegations, and get 3 or 4 or 5 allegations that are all come back unfounded. They can see it's occurring, but they don't have the training or background to diagnose it. So that really falls then to the psychologists to make that diagnosis of child psychological abuse. Is there a persecutory delusion, and is there a factitious disorder? A mental status exam of thought and perception is the assessment for persecutory delusion. We don't make diagnoses of delusions based on history. We pop it out in the session and take a look at it. That's the mental status exam of thought and perception. But nobody in the family course, none of the psychology people, forensic people, know how to do that. It comes out of schizophrenia as the people who know how to do it, but they're not working in the family courts. So you don't have the competence in the mental health people currently to conduct that assessment. Once there's motivation from the psychologists, they can learn the mental status exam, and then you will have the competence, but there's currently no motivation. So, it's just a mess over here. It's a nightmare. These psychologists are the worst imaginable, unethical, lazy, incompetent, and they don't care, apathetic, and participating in the child abuse as a result. And holy cow, a mental health person should never, ever be a participant in the child abuse. That's just bad. When a patient has to explain to the doctor what the pathology is, whoa, that's just really, really, really bad. Imagine going into your doctor for cancer and having to explain to your doctor what the cancer is and what the treatment is. To your doctor, you're explaining. That's insane. So, what you can do if there's current mental health involvement, what's the diagnosis guiding the treatment? Okay, all mental health professionals have a duty to protect obligations and diagnostic obligations. So especially individual therapists, if there's individual therapists involved, let's get their diagnosis and treatment plan, because my guess is they've misdiagnosed a shared delusion and they're believing the shared delusion, in which case they are participating in the child abuse. So I pretty much guarantee that 100% of the individual therapists are participating in child abuse because of their ignorance and incompetence. The mental health people are the child abusers. They should lose their license. Mental health people should not be child abusers. No. And yet they are. And nobody's stopping them. The licensing boards are corrupted with the forensic psychologists. They've been the ones that allowed the system to go down like this. Where are the licensing boards? Nowhere to be seen. And then you have the neglect from the APA that they just don't care. And so they just allow unethical practice in the family courts because I don't know why. Because you deserve to be abused somehow. Your children don't deserve competence. You don't deserve competence. The court doesn't deserve competence. And so they can just ignore you over here in the family courts. So what you do, if there's an involved person, you ask for a treatment progress summary. That's what we do that all the time. We write reports at intake. We write reports at discharge. And whenever you request them, we can write up a treatment progress summary. We don't need all their notes and stuff, just their summary. We want to get their diagnosis and treatment plan. Treatment plans should have goals, interventions, estimated timeframes for accomplishing those goals, and outcome measures on things. None of them have any of those key things. And so they're, again, just absolutely incompetent, the mental health people. But once we get that, we can then challenge the diagnosis. Once we get them to say, diagnosis is, I don't diagnose it, I didn't diagnose, or it's PTSD because the child was traumatized. And, no, there's no trauma here. And that's a false attachment pathology. So you misdiagnosed the shared delusion as being real. But we have to first get them on record about what their diagnosis and treatment plan is. And if it's accurate, yay. But if it's not, then we can challenge it and get a second opinion on their diagnosis. Um, and so I'll wrap up here today. Where we wind up is that all mental health professionals, the forensic psychologists and the master's level people too, in the family courts, but these are the APA ethics code. All forensic psychologists in the family courts are in violation of three ethical standards. Standard 2.01, boundaries of competence. None of them are competent in the assessment of delusional thought disorders. I know that because you get that training out of schizophrenia, and it's a mental status exam of thought and perception, and none of them are doing the mental status exam of thought, and they're not even considering persecutory delusion. I read the reports. I'm the scrutiny that, you get a custody evaluation and you bring it over to me and I do a line by line workup on it. So I'm reading what they're doing, and they're not competent in delusional thought disorders. They're not competent in attachment pathology. That comes out of early childhood mental health. None of them have early childhood mental health. Let me talk. I have early childhood. I know how the attachment system works. So let me clue you in on a little something. If there's severe attachment pathology in an older child, you will see evidence of that attachment pathology in the younger child. Attachment pathology just doesn't pop into existence in an 8-year-old or in a 12-year-old. The attachment system forms up in early childhood, 0 to 5. And once it kind of gets that system stable, it kind of remains stable. We can do a little stuff. We can move an insecure to a secure kind of stuff. But you don't see massively disruptive stuff. What child abuse does is it produces what's called a disorganized attachment. So if you have an abusive parent, you're going to see that level of disorganized attachment from the get-go, from the start, because that parent is pathological. So you see a continuity to the attachment pathology. Over here in the family courts, though, that doesn't show up. All of a sudden, you have like a normal kid for a bunch of years, and then all of a sudden they develop the worst possible attachment pathology towards a parent. That doesn't happen. Okay, you don't ever see that in the rest of the world, and that's something to keep in mind. If you only see something in the family courts, it's not a real thing, because if it's a real thing, you see it everywhere. So where do you see children rejecting parents? Almost nowhere. The only possible places sometimes is real severe child abuse. And so we will assess for that. If you see a child rejecting a parent, well, is a targeted parent abusing the child? But it's odd. That's an odd attachment pathology just so proud into being, and there's no history of it prior to that, because attachment pathology is historical. You'll see those symptoms early on too, in the early childhood all the way up through. If there's no, if the targeted parent is not abusing the child, it's the allied parent. We got a narcissistic, borderline, dark personality parent. We know they exist. We know they're in the family courts. We need to identify them and protect the child from that person. So then the other is 2.04, bases for scientific and professional judgments. There's no such thing as parental alienation. There's no such thing as resist, refuse. There are delusional thought disorders. There are factitious disorders. There's family systems and cross-generational coalitions and emotional cutoff. There's all sorts of actual things, psychological control, Barber. There's all sorts of actual things, and they need to know 2.01 and apply 2.04, the established scientific and professional knowledge of the discipline as the basis for their professional judgments. And then the third violation is because they do not know the established knowledge of psychology. They're not competent. So that's a violation of 2.01. And they did not apply the established knowledge as a basis for their professional judgments, a violation of 2.04. Then their opinions, 9.01, their opinions as contained in their recommendations, reports, diagnostic and evaluative statements, including their forensic testimony, is not based on information and techniques sufficient to substantiate their findings. The information is the established knowledge, 2.04. Standard 9.01 cites directly back to 2.04. And the techniques in this case would be the mental status exam of thought and perception. So pretty much every forensic custody evaluation I review comes back with these glaring ethical violations by the forensic psychologist. And so, going back to the beginning, the New York Blue Ribbon Commission on Forensic Custody Evaluations recommends the elimination of them. They lack scientific and legal value. They are harmful to children. They're potentially dangerous and can lead to disastrous consequences for the child and family. So, as a legal professional, as an attorney representing the targeted parent and the child, begin to think we need to start thinking clinical and treatment rather than custody. This is not a custody issue. This is a pathology and treatment issue. We need to get it out. Possible child abuse. We need to get it out to get an accurate diagnosis. There's going to be barriers to that. Those barriers can be overcome through consultation. And then ultimately, the field will begin to shift once the American Psychological Association gets over here and cares about what's happening in the unethical practice. And that they're going to have to take a look at themselves and their own collusion. The APA is colluding with the unethical practice and child abuse in the family courts because they don't even support their own ethics code. The APA doesn't. And so there's a nightmare. So with that, I'm going to head off to my Sunday, and good luck, everybody.